Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a fascinating book in a subject which to many people appears to be easy, but it isn't. It's much more complex than people think. It's the subject of criminal law, and this book comes to us from a European publisher called Intersentia Limited. They're based in Cambridge and also abroad. The book has got a title, Comparative Concepts of Criminal Law, and it's been edited by two people, Johannes Keiler and David Roef. Now, Elizabeth and I talked about this book to get some idea of our approach with the review. And our review title for what we've written about the book is as follows: a unique and thoughtful introduction for students to substantive criminal law using comparative concepts. Now, a lot of words involved in that, but what does that mean? Well, we'll come on to that in a minute. Let's look at the book first of all. It's a paperback. There we go, front, spine, and then the back. It runs to something like under 300 pages. You can see the structure of the book here. It's different from many. There's information about the authors right at the back. There's no index. You do have paragraph numbering, which you can see at the sides at the bottom there. Footnotes rather, and paragraph the paragraph numbering to go with it. The footnotes at the bottom and the paragraph numbering. As I say, there's no actual index. At the front, though, what you do have is there's the front page there. Then you've got acknowledgements about the book itself. Then the contents section, which is quite detailed. And you can see from the detail of the contents most of what you should be able to find. And you'll see who has written which chapter, because their names are fairly prominent throughout. And there again we run through the various chapter headings. There we go. And then you get to list of abbreviations. Again, very helpful because we've got a link here not just with the English legal system, but of course European models as well. There is the end of the abbreviations, and then you start the introduction, the general purpose of the book. It's worth reading the introduction because it does give you some idea of what their purpose was and what is called the comparative approach. Because what we're looking at here is, and if I can simplify this, we're looking at a comparison between the various legal systems and how we approach the issue of criminal law. Now, that is an area which has been the subject of a lot of discussion for some time. The European Union are looking, I think, in the longer term, certainly over this century, the 21st century, of having a much more unified structure for criminal law. And I would think the day will come, apart from rogue regimes, where we will have an international established set of rules on criminal matters, which will be generally adhered to. Obviously the issue of sanctions and other matters is a separate one, in other words sentencing. But I think we are moving much more towards that, which if one thinks about it makes some sort of sense. But where we are today in 2015 is looking at comparing the concepts of criminal law in different jurisdictions, and that's what this book is about. So I think it would be useful from both the jurisprudential point of view and also from all of the points of view of those today who are actually studying criminal law, and also of course European Union law, although that is of course predominantly civil. This is what we say about the book. The two authors, Johannes Keiler and David Roef, pay a generous and sensitive tribute to Dr Peter Bal, who was responsible for the genesis of this short handbook. Its purpose is to identify and explain some fundamental concepts and rules of substantive criminal law, and that means criminal liability, and the editors tackle their task with relish. The book is modestly described, quote, as unique in the sense that it introduces the reader to the fundamental concepts and rules of substantive criminal law in a comparative way, and not just to the criminal law system of one specific jurisdiction. For instance, in our case, the English legal system, and the fact that our common law has been honed away over 800 years. And that is exactly, of course, what this book does, because it's written in a very readable manner, which I think the undergraduate will appreciate if he or she are new to the subject, because criminal liability is nothing like as simple as many at first presume, and I've seen it happen, having both done the subject as an undergraduate and also, of course, having taught it. that people do come to the subject with preconceived notions, having watched something on the television, and it's the same with evidence. They think they've got some idea of what's going on. Fortunately, not necessarily that to be the case. So therefore this book does have, I think, a tremendous authority behind it in putting forward where we are at the moment with comparative systems. The academic community recognises that compared with other areas of substantive law, such as the law of contract and the law of real property, comparative research into the so-called general part of criminal law remains, quote, quite a phenomenon within academia, never mind transmitting this knowledge to students of law. And of course added to this is the developing Europeanisation of criminal law, which I referred to of course earlier, and its policies, making such a comparative approach even more necessary, and that's where the new title from Intersentia comes to the rescue, with their specialist legal approach to volumes which cater for a very rigorous intellectual survey of their subject matter. So, Comparative Concepts of Criminal Law as a super short handbook fills the legal educational gap we still have in jurisprudence in our view, and it gives an exploration of the basic concepts of substantive criminal law in three major European legal systems: the common law system of England and Wales, and the civil systems of Germany and the Netherlands. And in essence it has a handy continental approach which it fits nicely into modern legal teaching to give the subject some rounded perspective, and that's what you get here. Each chapter in the book focuses on a specific concept or doctrine that is necessary to determine criminal liability. For example, the Latin tags we have will not change for actus reus and mens rea, and for defences, inchoate offences, and so forth. Let me conclude by saying the title also highlights and develops a discussion on some recent legislative and judicial developments which broaden the scope of criminal liability in our modern culture of control, and will be, I think, of interest to sociologists, and applied criminologists. So in short, the book is rightly described as not only an invaluable book for students, but also for legal practitioners who want to broaden their knowledge of criminal law. Intersentia and the authors have done just that, and the title fits the bill nicely in our view for the modern student who is looking for both a high level and quality of explanation, and that's what they get here. So thank you to the authors and the publishers for an excellent new publication. Let's have a very quick look at it again. There's the front cover, there's the spine, and then there's the back. Just opening it in the middle, forms and aspects of mens rea, right in the middle there. You see it's got the footnoting and the paragraph numbering. Again, there's quite a lot of Latin in places, and of course there will be words. We've got, for instance, here, strict liability. There are going to be some words that you're probably not that familiar with, but I do think that it's a book that will open up the picture of criminal law in terms of the European aspects and give a much more grounded view of where we are today with the subject. So thank you very much to all concerned for an excellent new publication. Bye-bye.